Welcome to the Republican Professor. I'm my own host, Dr. Lucas J. Mather. It's 12 November 2023, 25 years after Jesus. We have a reading from Psalm 32 in the King James Version. Let's get to it. Blessed is he whose transgression is forgiven, whose sin is covered. Amen, brother. Blessed is the man unto whom the Lord imputeth not iniquity, and in whose spirit there is no guile. When I kept silence, my bones waxed old through my roaring all the day long. Verse 4, for day and night thy hand was heavy upon me. My moisture is turned into the drought of summer. I acknowledged my sin unto thee, and mine iniquity have I not hid. I said, I will confess my transgressions unto the Lord, and thou forgavest the iniquity of my sin. Verse 6, for this shall every one that is godly pray unto thee in a time when thou mayest be found. Surely in the floods of great waters they shall not come nigh unto him. Thou art my hiding place. Thou shalt preserve me from trouble. Thou shalt compass me about with the songs of deliverance. Verse 8, I will instruct thee and teach thee in the way which thou shalt go. I will guide thee with mine eye. Be ye not as the horse or as the mule, which have no understanding, whose mouth must be held with bit and bridle, lest they become near unto thee. Many sorrows shall be to the wicked, but he that trusteth in the Lord, mercy shall compass him about. Verse 11, and this is the final verse. Be glad in the Lord and rejoice, ye righteous, and shout for joy, all ye that are upright in heart. Psalm 32, King James Version, a moment of reflection. Now we have a reading from January 17th, Streams of the Desert, Cowman Publications. Los Feliz Station, Los Angeles, California, 1925, the non-woke edition. O Daniel, servant of the living God, is thy God whom thou servest continually able to deliver thee. Daniel 6:20. How many times we find this expression in the scriptures, and yet it is just this very thing that we are so prone to lose sight of. We know it is written, the living God, but our daily life, in our daily life, there is scarcely anything we practically so much lose sight of as the fact that God is the living God, that he is now whatever he was 3 or 4 thousand years since, that he has the same sovereign power, the same saving love toward those who love and serve him as ever he had, and that he will do for them now what he did for others 2, 3,000, 4,000 years ago, simply because he is the living God, the unchanging one. Oh, how therefore we should confide in him, and in our darkest moments never lose sight of the fact that he is still and ever will be the living God. Be assured, if you walk with him and look to him and expect help from him, he will never fail you. An older brother, page 20 at the top, who has known the Lord for 44 years, writes this, says to you for your encouragement that he has never failed him. In the greatest difficulties, in the heaviest trials, in the deepest poverty and necessities, he has never failed me. But because I was enabled by his grace to trust him, he has always appeared for my help. I delight in speaking well of his name. That's from George Mueller. Luther was once found at a moment of peril and fear when he had need to grasp unseen strength, sitting in an abstracted mood, tracing on the table with his finger the words, "Vivit, vivit, he lives, he lives." It is our hope for ourselves and for his truth and for mankind. Men come and go. Leaders, teachers, thinkers speak and work for a season and then fall silent and impotent. He abides. They die, but he lives. They are lights kindled and therefore sooner or later quenched, but he is the true light from which they draw all their brightness, and he shines forevermore. That's Alexander McLaren. One day I came to know Dr. John Douglas Adam, writes C.G. Trumbull. I learned from him that what he counted his greatest spiritual asset was his unvarying consciousness of the actual presence of Jesus. Nothing bore him up so, he said, as the realization that Jesus was always with him in actual presence, and that this was so independent of his own feelings, independent of his own deserts, and independent of his own notions as to how Jesus would manifest his presence. Moreover, he said that Christ was the home of his thoughts. Whenever his mind was free from other matters, it would turn to Christ. And he would talk aloud to Christ when he was alone on the street, anywhere, as easily and naturally as to a human friend. So real to him was Jesus' actual presence. Streams in the Desert, 17 January 2, well, originally published in 1925, a moment of reflection. We're back in Bostock today. Bostock Dissents. We got halfway through A last time. If you recall, it was October 22nd, I believe. Yeah, October 22nd. We are back here in finishing up A. And this is a very important dissent. Remember, this is about the 1964 Civil Rights Act, the word sex, whether it encompasses so-called transgender legal status, whatever that means and however that is triggered, and which the court doesn't really talk about, which is a little troubling, I would say. It's a little troubling. Um, so we are going to proceed with trying to escape the consequences. It's about halfway through Roman numeral 1A in the dissent, the first dissent written by Alito, joined by uh, Thomas. Don't know who that is. Alito and Thomas. Hmm. I'll have to look that up. Okay, Judge Alito, joined by Thomas. Roman numeral 1A. We just finished the court's chief arguments collapses. So just search chief argument and you'll come right to the spot. Trying to escape the consequences of the attorney's concession, the court offers its own hypothetical. Suppose an employer's application form offered a single box to check if the applicant is either Black or Catholic. If the employer refuses to hire anyone who checks the box, would we conclude that the employer has complied with Title VII, so long as it studiously avoids learning any particular applicant's race or religion? Of course not. How this hypothetical proves the court's point is a mystery, Alito says. A person who checked that box would presumably be Black, Catholic, or both. Well, that's an interesting point right there. You're assuming that they're being honest, right? And that there's a truth to being Black or Catholic that would be publicly accessible somehow. I mean, if you have to ask the person, is it really that obvious? And then, in which case, if it's not obvious, why would it matter in an employment context? But in any case, I'm just going to point that out. Why are there these kinds of boxes on any application form at all, including for the government? I mean, asking your race, your gender, your sexual orientation, you know. How this hypothetical proves the court's point is a mystery. A person who checked that box would presumably be Black, Catholic, or both, and refusing to hire an applicant because of race or religion is prohibited by Title VII. Rejecting applicants who checked a box indicating that they were homosexual is entirely different because it is impossible to tell from that answer whether the applicant is male or female. Very good. Unless you're going to beg the question and assume without proper documentation or evidence or justification that homosexual is covered by sex, which is begging the question, I think. The court follows this last comment was my comment. It wasn't Alito's comment. Uh, the court follows this strange hypothetical with an even stranger argument. The court argues that an applicant could not answer the question whether he or she is homosexual without knowing something about sex. If the applicant was unfamiliar with the term homosexual, the applicant would have to look it up or ask what the term means. And because this applicant would have to take into account his or her sex and that of the persons to whom he or she is sexually attracted to answer the question, it follows, the court reasoned, that an employer could not reject this applicant without taking the applicant's sex into account. I'm going to add here that it also assumes that that people can determine relatively easy with relatively little investigation, meaning just by looking, whether someone is male or female, whether someone is a man or a woman, if that's what you're sexually attracted to. Okay. This is illogical, Alito says. Just because an applicant cannot say whether he or she is homosexual without knowing his or her own sex and of the persons to whom the applicant is attracted, it does not follow that an employer cannot reject an applicant based on homosexuality without knowing the applicant's sex. While the court's imagined application form proved nothing, another hypothetical case offered by the court is telling. But what it proves is not what the court thinks. The court posits, here's a quotation from the majority opinion, Gorsuch. Imagine an employer who has a policy of firing any employee known to be homosexual. The employer hosts an office holiday party and invites employees to bring their spouses. A model employee arrives and introduces a manager to Susan, the employee's wife. I think we're assuming Susan is a woman, are we not? Will that employee be fired? If the policy works as the employer intends, the answer depends entirely on whether the model employee is a man or a woman. It also depends, I would add, Mr. Alito, whether uh, being married to someone entails anything about who you were sexually attracted to the person. But hey, that's a different topic for a different day, I suppose. Alito continues, this example disproves the court's argument because it is perfectly clear that the employer's motivation in firing the female employee had nothing to do with that employee's sex. The employer presumably knew that his employee was a woman before she was invited to the fateful party. Yet the employer, far from holding her biological sex against her, rated her a model employee. At the party, the employer learned something new, her sexual orientation, we're assuming. And it was this new information that motivated her discharge. So this is another example showing that discrimination because of sexual orientation does not inherently involve discrimination because of sex. Yeah, that seems to follow. I'm just going to add my 2 cents here. I think that that seems to follow. This paragraph right here by Alito seems to be pretty devastating to Bostock versus Clayton County. And this is on 1760 in the Google Scholar edition, which is the Supreme Court reporter. In addition to the failed argument just discussed, the court makes two other arguments, more or less in passing. The first of these is essentially that sexual orientation and gender identity are closely related to sex. The court argues that sexual orientation and gender identity are inextricably bound up with sex, and that the discrimination on the basis of sexual orientation or gender identity involves the application of sex-based rules. This is a variant of an argument found in many of the briefs filed in support of the employees and in the lower court decisions that agreed with the court's interpretation. All these variants stress that sex, sexual orientation, and gender identity are related concepts. The Seventh Circuit observed that, quote, it would require considerable calisthenics to remove sex from sexual orientation, unquote. The Second Circuit wrote that sex is necessarily, quote, a factor in sexual orientation, unquote. and further concluded that, quote, sexual orientation is a function of sex, unquote. Bostock's brief and those of amici supporting his position contend that sexual orientation is a sex-based consideration. Other briefs state that sexual orientation is a function of sex or is intrinsically related to sex. Similarly, Stevens argues that sex and gender are necessarily intertwined. By definition, a transgender person is someone who lives and identifies with a sex different than the sex assigned to the person at birth. Stevens argues that, and that's a quotation. A transgender person is someone who lives and identifies with, a sex different than the sex assigned to the person at birth. Let me read this again and see. Can you wrap your mind around this? Similarly, Stevens argues that sex and gender are necessarily intertwined. Quote, by definition, a transgender person is someone who lives and identifies with a sex different than the sex assigned to the person at birth. Someone who lives and identifies with a sex different. I mean, that's very confusing to me. If you live with a sex different, it sounds like you might be cohabitating. Maybe it's a heterosexual arrangement by definition. Sex different. Hetero means different in Greek. Uh, Someone who lives a sex. That doesn't make any sense. Someone who lives a sex. There's what's the object of this verb? Someone who lives. What's the what's the indirect object? Someone is the subject who lives. Okay, who lives, that's the verb, and identifies, that's a verb, but I don't know what that means. What's that verb mean? With a sex, that would be an indirect object. What are we talking about here? With a sex. That's a prepositional phrase. I don't know what with a sex means. With a sex. This is so confusing. I mean, you guys, this is why we're going through this here, is the so-called transgender people and their activist friends. They would call them allies because they love war language. Everything's a war to them. You know, we can't just get along. We're at war. It's constant war, constant battle with these folks. And one of their warlike ways is to assume something with like an air of moral superiority, self-righteousness, in such a way that you don't ask any questions. You're shamed in out of asking questions when you might genuinely be perplexed and not know what the hell they're talking about. And the fact that this is tied to a federal statute or an interpretation of a federal statute, which has problems because the theory itself has problems and this application to reality has problems. So it's tied to federal liability in small business employment, big business employment, corporate employment, nonprofit employment, government employment. What could possibly go wrong? I mean, if there is genuinely an unclarity or an incoherence, a metaphysical incoherence, and everybody's just assuming that, not everybody, but everybody on that side and their quote unquote allies, the strategy of war, the ally war kind of thing, the strategy is to just assume you're right without proving it or without giving evidence, without clarifying and arguing and under normal standards of epistemic duties to show that there's some kind of correspondence with reality, correspondence theory of truth that you're satisfying. To just assume that those standards don't apply to you in this context, while there's federal liability attached to these unclarities. This is a disaster. It's a disaster for higher education for sure. This has a chilling effect on free speech on campus. And that's my employment. That would be in my employment. So that's my work environment. That's a hostile work environment. It creates a hostile work environment, not just in the issue of religion and free expression, free speech, free press, whatever you want to call it. I know that, you know, people are going to say different things about you give up certain freedoms to work different places. But definitely on the college campuses, there should be a free exchange of ideas and argumentation. And I don't think that you have to constantly hide behind your religion or free expression, freedom of free exercise of religion. I don't think you should be constantly trying to strategize how to stuff this in that box. Because what about all your critically thinking agnostic and atheist friends? What are they going to do? They're hung out. You don't hang them out to dry. This is a problem with epistemic norms here. Okay? Don't run to the free expression clause or the free exercise clause to just shield yourself from liability. Although I understand why you would do that and why attorneys would suggest you do that, but I'm going to suggest that that's the wrong thing to do politically. This is a political problem. It can be fixed by Congress. It's just a statute. It's not handed down from God to Moses. It's a statute that Congress just came up with, and it's just people on some courts applying a problematic interpretation to a statute. This can be overturned by Congress. It can also be overturned. It can also be subject to influence from the electorate in future appointments to the courts when they go through the vetting process by the executive who nominates them, either at the state or federal level, and the confirmation process, which is political. So you need to be aware of these issues. And I'm trying to give you some give you some courage, man. Come on. Stop being so afraid. Maybe it's not fear, maybe it's just ignorance, and you're wondering why everybody else seems to get it and I don't. Well, maybe you're not ignorant. Maybe you're sensing that there's a deep problem here. Maybe you can't articulate it, but maybe you will after reading this, listening to this. We continue with Alito. It is curious to see this argument and opinion that purports to apply the purest and highest form of textualism because the argument effectively amends the statutory text. Title VII prohibits discrimination because of sex itself, not everything that is related to, based on, or defined with reference to sex. By the way, kids, notice he said based on, not based off. cannot tell you how many times I've heard based off. No, it's based on. Come on, guys. Really? Based off? Really? Many things are related to sex. Think of all the nouns other than orientation that are commonly modified by the adjective sexual. Some examples yielded by a quick computer search are sexual harassment, sexual assault, sexual violence, sexual intercourse, and sexual content. Does the court really think that Title VII prohibits discrimination on all these grounds? Is it unlawful for an employer to refuse to hire an employee with a record of sexual harassment in prior jobs or a record of sexual assault or violence? This is what you call a reductio ad absurdum in the business. Yeah. I'm a, I'm going to read to you from the rule book for arguments, which is required for me for a long time ago. Under deductive arguments, okay. I don't know how my audio went off with my. Seems like I pushed something on these AirPods. Sorry if the sound is messed up because I'm moving around my earpods. I apologize for that. I This is the second time I'm using these and I don't really know what I'm doing. Sorry about that. Working through some technical things. I'm hoping that this is going to be a good experience for you to listen to it without distraction. Under deductive arguments on page 55, this rule book for arguments by Anthony Weston, second edition, is goes over the reductio ad absurdum form in a deductive context. One traditional deductive strategy deserves special mention, even though, strictly speaking, it's only a version of modus tollens. This is the reductio ad absurdum, or reduction to absurdity. To prove P, assume not P. That is, assume that P is false. From the assumption, derive an implication Q. Show Q is false. Contradictory, silly, absurd. That's why I feel like I don't think this isn't deductive only kind of thing because silly is not a deductive category. Absurd might be because you might say absurd is the same thing as contradictory, but silly is not a deductive category. And he does use the word silly there. I think that reductio ad absurdum is a form of argumentation that you could use in abduction and induction as well. So it conclude P. Arguments by reductio, as these arguments are often called, thus establish their conclusions by showing that the denial of the conclusion leads to absurdity. That's the key idea right there. There's nothing left to do, the argument suggests, but to accept the conclusion. Remember, for example, the argument for the existence of a creator, which we discussed in section 12. Houses have creators, the argument goes, and the world is like a house. It too is ordered and beautiful. Thus, the analogy suggests the world must have a creator too. I think that's not a deductive argument. That's an argument by analogy, which is why I'm not sure why he's got this in the deductive area. An argument by analogy is not a deductive argument um, necessarily. I guess you could phrase it like that, but um, So the general idea, the general strategy is there is nothing left to do but accept the conclusion, except when you can't accept the conclusion. Maybe it's existentially unviable. You can't live it. Or it's not merely silly, it's irresponsible somehow, either epistemically or morally. There, you have to go back and find out what was wrong with the argument, with the premises, with the reasoning from the premises to conclusion. And I think that's broadly speaking what Alito is doing here. He's saying to accept the conclusion that you are prohibited from considering a record of sexual assault or violence or sexual harassment in hiring or firing or promotion, these categories of employment conduct that are covered under Title VII of the 1964 Civil Rights Act, to say that those could not be considered because of an interpretation of civil rights legislation is an absurd result. Therefore, we must go back and reject what led to the absurdity. And he's saying the thing that we need to go back and reject is the assumption that sex in the 1964 Civil Rights Act encompasses transgenderism and homosexuality, just because those things are related to sex and cannot be understood without reference to sex. I hope that that makes sense. If it doesn't, maybe go back and listen to it again or read this again, listen to it again and read it again. To be fair, you weren't being fair before, Alito? I hate it when people start with to be fair. Aren't we in a fair context? We weren't in a fair context up until this point. Now all of a sudden we're in a fair context. To be fair, I guess it's just an expression that people use. The court does not claim that Title VII prohibits discrimination because of everything that is related to sex. The court draws a distinction between things that are inextricably related and those are related in some vague sense. Apparently, the court would graft onto Title VII some arbitrary line separating the things that are related closely enough and those that are not. Oh, so like an interest balancing, kind of a means end scrutiny, a degree thing. Interesting. And it would do this in the name of high textualism. It's clever. I like that. Good job, Alito. An additional argument made in passing also fights the text of Title VII and the policy it reflects. The court proclaims that an individual's homosexuality or transgender status is not relevant to employment decisions. That is the policy view of many people in 2020, and perhaps Congress would have amended Title VII to implement it if this court had not intervened. But that is not the policy embodied in Title VII in its current form. Okay, catch this here. Title VII prohibits discrimination based on five specified grounds, and neither sexual orientation nor gender identity is on the list. As long as an employer is free to decide for itself which characteristics are relevant to its employment decisions. Ooh, I got to read that again. As long as an employer does not discriminate based on one of those listed grounds, the employer is free to decide for itself which characteristics are relevant to its employment decisions. By proclaiming that sexual orientation and gender identity are not relevant to employment decisions, the court updates Title VII to reflect what it regards as 2020 values. Let me say something about this last sentence there. By proclaiming that sexual orientation and gender identity are not relevant to employment decisions, the court updates Title VII to reflect what it regards as 2020 values. The reason Alito is putting this in here is because the Democrats are most certainly doing that. The Republicans, though, should not agree that this is the right way to go because it flies in the face of their theory of statutory construction. The theory of statutory construction in the Republican sense, in the normative sense of being a Republican, is that the court's limited role by the Constitution is to interpret what the text itself is saying, and the court's role is not properly to update what it thinks Congress should have said but didn't. And the court's role is not properly to update a statute to reflect what it regards as current values. That's Congress's job. So that would be a separation of powers issue, a constitutional issue within the context of statutory construction. Because as Judge Brett Kavanaugh said when he was on the DC Circuit, every case that comes before the court is a constitutional case in the sense that it's a separation of powers case, because every case is about, in some sense, the power of the court, what it's properly empowered to do versus not empowered to do properly compared to the legislature. Okay. Alito continues, this court's remaining argument is based on a hypothetical that the court finds instructive. In this hypothetical, an employer has two employees who are attracted to men, and to the employer's mind, the two employers are materially identical except that one is a man and the other is a woman. The court reasons that if the employer fires the man but not the woman, the employer is necessarily motivated by the man's biological sex. After all, if two employees are identical in every respect but sex, and the employer fires only one, what other reason could there be? The problem with this argument is that the court loads the dice. That is so because in the mind of an employer who does not want to employ individuals who are attracted to members of the same sex, these two employees are not materially identical in every respect but sex. On the contrary, I like that. I'm going to just insert right here. I like that. I think Alito is correct. I wish he would say the problem, though. The problem is begging the question. The problem is begging the question. What is begging the question? I'm going to tell you. I'm in a book that I used for many years, many years, about 20 years of teaching. This particular edition is the 10th edition, and it's Patrick Hurley's Concise Introduction to Logic. I would love to teach through this on YouTube, but I don't think YouTube is the right, I don't think it's the right platform for teaching through that. I think that it's got to be something that's a bit more tightly controlled and not censored, not able to be censored. So I don't know how that would work, but I don't think it can be on YouTube. And also, I hesitate to put a lot of effort into something on YouTube like that because people don't take it seriously. The very context of a YouTube classroom is a joke, which is a criticism of this podcast, I suppose, because we're on YouTube. But there's so many distractions on YouTube, and YouTube does not have any incentive for you to watch this entire thing with no ads. They have no, in fact, they have every incentive for you not to watch this at all and to move on because I don't make YouTube any money. I'm not monetized. And they are constantly trying to get you to be distracted to go to a different video where there are ads and they make money on ads. So, and by the way, YouTube is totally the opposite political party. So there's a double problem with using YouTube to teach logic. Does that make sense? I had to get a drink of water, so I muted myself. Now, in chapter 3 of Patrick Hurley's Concise Introduction to Logic, Informal Fallacies, section 3.4, fallacies of presumption, ambiguity, and grammatical analogy. Begging the question is number 15 of all of the fallacies that he covers in this chapter. And in the 10th edition, it's on page 149. And so I'm going to turn there. Yes, I do have a physical book. And if you're interested in studying logic with me, I'd be happy to help you. The first thing I would suggest is you have to get a physical book and we have to be on the same page, as it were. Get a book that cannot be censored by anybody else. Get it. Get 2 or 3 different versions of an older logic book. What I mean by older is not brand new. Here's begging the question. The fallacy of begging the question is committed whenever the arguer creates the illusion that inadequate premises provide adequate support for the conclusion by leaving out a possibly false, I don't like the way he says it, possibly false would include any contingent statement. Possibly false, shaky key premise. I would say shaky is better than possibly false. I would, but he didn't. Did he ask me to review this? I can't remember. Now I have to ask. Now I have to look and see. I know that I did review it and they paid me to review this. I don't think I got any credit though. Um, Now I'm interested in seeing if they put my name in there. Well, maybe they did. Maybe they didn't. It would be under M. Okay, well, they didn't give me any credit for it, but they did pay me. I think it's because I was pretty critical of certain things. Funny how that works, huh? Well, I did review logic and philosophy, and they did give me credit for it. So that was kind of cool. Peterson, Miller, McReynolds. Okay. Yeah. Scott McDonald, University of Iowa. Must have been before he went to Cornell, I think. Mayhew. Yeah. Mayor, Mans. Okay. Yeah, I'm not in the acknowledgments. But that's all right. They did pay me to review this, and I said stuff like this that, don't use possibly false, shaky key premises. by restating a possibly false premise. Again, I don't like that word, uh, possibly false, as the conclusion, or by reasoning in a circle. Okay, that's the key issue, reasoning in a circle. The Latin name for this fallacy, principio principi, petitio principi, sorry, means request for the source. The actual source of support for the conclusion is not apparent. And so the argument is said to beg the question. After reading or hearing the argument, the observer is inclined to ask, but how do you know X? Where X is the needed support. Now, finding out what X is sometimes a little bit tricky in the case of begging the question. When there's a genuine case of begging the question fallacy, it's it's oftentimes not clear what was assumed, which needs evidential support and or clarity. And so in this context, Alito is correct, but he really should say the court is begging the question. He says the court loads the dice. Um, what we're begging the question about is something that you need to get clear here. He says that is so because in the mind of an employer does not want to employ individuals who are attracted to members of the same sex. These two employees are not materially identical in every respect but sex. Well, they are if uh, sex is broad enough to include everything related to sex or things that are closely related to sex. And that's the very thing that needs to be defended. That's the thing that the court doesn't really defend. That's begging the question. On the contrary, they differ in another way that the employer thinks is quite material. And until Title VII is amended to add sexual orientation as a prohibited ground, this is a view that an employer is permitted to implement. Okay. I'm going to give you an example of begging the question in the marriage context, the definition of marriage. If you assume without clarity or argument that the definition of marriage does not have anything to do with sex of the relata, that those things that are related by the relation of marriage, well, then it's a lot easier to legally apply a constitutional rule to definitions in a statute that would otherwise be arbitrary, like an equal protection assumption. But if marriage is inherently the kind of thing that does take account of the differences of the sex of the relata, those individuals that are related by the relation of marriage, then that doesn't follow at all. And that's the very thing that needs to be at issue, is what the definition of marriage is. That's the very issue. That if you don't get that clear and that evidentially supported either way, it's begging the question. Now, marriage was in the dictionaries and in common speech and in our history and tradition, union between a man and a woman by which they become husband and wife. You can look that up in Noah Webster's 1828 dictionary, which is online now. You can search that. And that's the same exact definition of marriage as hundreds of years before in English. And even before that in Greek and Latin and Chinese and Hebrew. But in the context of English, it's the same definition that was in the Oxford English Dictionary in 2015, a dictionary that was based on billions of examples of usage. Empirically speaking, that's the usage of the term. So, in the context of begging the question doesn't really apply in a legal context when the tradition is uniformly one thing. You would just say the legal authority is the tradition. That's just what it is. And when you're talking about something like marriage, that just it doesn't make any sense to add the word traditional to the word marriage because marriage itself is traditional. Where else would it come from? It wasn't invented yesterday. The whole reason people are interested in, quote, getting married is because of what they have in their minds from the tradition. I mean, they have something in their minds, and that was from the tradition. I mean, why do you think they want us to have a wedding cake? That's a traditional element. Why do you think they want to have, tuxedos and dresses and a wedding ceremony at all? Why do you think they even want the word marriage? The word itself is traditional. So everything about it is traditional. That's just what it is. I mean, it's kind of like other ordinary nouns that you can see, like take, for example, an apple. I walk into Trader Joe's. I don't say I want a traditional apple, as opposed to what? A non-apple? And that's what we're talking about. Every correct sense of a term is going to exclude the non-examples and include the examples. That's just what a correct definition does. It's not to discriminate against people, it's to discriminate between one sense of the term and another term that you don't mean. And that's the function of language. Now, this is very difficult material to master. It takes a while to become comfortable with, but and proficient with. The political challenge in this context, in terms of this kind of argumentation and reasoning, is that there's a political strategy on the Democrats' side which distracts from correct reasoning because they want to make you defensive by calling you names, by attacking your character, uh, by muddying the waters. And again, assuming a moral superiority without any kind of argumentation or evidence. It's just kind of assumed and just kind of like get with it. It's kind of like everybody's wearing jeans in a certain way in seventh grade or rolling it up at the bottom. And if you're not rolling your jeans up, then what's wrong with you? And that's not uh, when I was in seventh grade, people were doing that, and I I pulled the begging the question hat. It didn't make me popular. Still, people didn't want to sit with me at lunch. It was very lonely. It was hard, but I wasn't wrong. And sometimes it's, especially for young people, it's very difficult to distinguish being wrong from being unpopular. And Democrats exploit that, especially in the young and especially in the older people that are impressionable because they're weak-minded, they're grade inflated, or they're just temperamentally more vulnerable to peer pressure. So that's a challenge in understanding this material, but that's why I'm here to help you. Hope this is helpful. Um, Now, there's a lot more here on begging the question. There's a couple of different, well, there's 3 or 4 different pages that I could talk about, but I'm not gonna do that because I don't want to turn this into an informal logic lesson. We got to get through this. Um, as noted, other than prohibiting discrimination on any of 5 specified grounds: race, color, religion, sex, and national origin, Title VII allows employers to decide whether two employees are materially identical. Even idiosyncratic criteria are permitted. If an employer thinks that Scorpios make bad employees, an employer can refuse to hire Scorpios. Such a policy would be unfair and foolish, but under Title VII, it is permitted. And until Title VII is amended, so is a policy against employing gays, lesbians, or transgender individuals. I would uh, alter that by saying, so is a policy against employing homosexuals or so-called transgender individuals. Once this is recognized, what we have in the court's hypothetical case are two employees who differ in 2 ways: sex and sexual orientation. And if the employer fires one and keeps the other, all that can be inferred is that the employer was motivated either entirely by sexual orientation, entirely by sex, or in part by both. We cannot infer with any certainty, as the hypothetical is apparently meant to suggest, that the employer was motivated even in part by sex. That's very good. He totally nailed this part. Nice job, Alito. The court harps on the fact that under Title VII, a prohibited ground need not be the sole motivation for an adverse employment action, but its example does not show that sex necessarily played any part in the employer's thinking. The court tries to avoid this inescapable conclusion by arguing that sex is really the only difference between the two employees. This is so, the court maintains, because both employees are attracted to men. Of course, the employer would couch its objection to the man differently. It would say that its objection was his sexual orientation. So this may appear to leave us with a battle of labels. If the employer's objection to the male employee is characterized as attraction to men, it seems that he is just like the woman in all respects except sex, and that the employer's disparate treatment must be based on that one difference. On the other hand, if the employer's objection to sexual orientation or homosexuality, the two employees differ in 2 respects, and it cannot be inferred that the disparate treatment was due even in part to sex. That's the key thing right there. He just put the nail in the coffin of the majority opinion written by Gorsuch. The court, wow, nice job, Ali. We continue. We're almost done with this section. The court insists that its label is the right one, and that presumably is why it makes such a point of arguing that an employer cannot escape liability under Title VII by giving sex discrimination some other name. That is certainly true, but so is the opposite. Something that is not sex discrimination cannot be converted into sex discrimination by slapping on that label. Very good. Very good. That's the key thing right there. I'm highlighting it for you on YouBoob. Something that is not sex discrimination cannot be converted into sex discrimination by slapping on that label. In other words, the labels should be applied correctly. And how do we know that the court is applying it correctly? It's just throwing the label on, and the label is doing it what it thinks is the work of reasoning. It's not. It's begging the question. And I would suggest that Alito um, use that terminology. So the court cannot prove its point simply by labeling the employer's objection as attracted to men. Rather, the court needs to show that its label is the correct one. Okay, so yeah, we're talking about begging the question. So, guys, in other words, study logic, it does matter. And, you know, I have a little bit of an anecdote. Okay, I taught logic at Pepperdine for many years. In one particular class, I think it was fall of 2010, I had a student named David Phillips in class. And he was one of the best students I've had at Pepperdine. In fact, that I have ever had anywhere out of, I don't know how many thousands of students at 12 colleges and universities over 20 years. David wanted to be an attorney and was taking the logic class. He took a couple of other classes from me as well. And and teaching that class, I used some pretty difficult material, including some court decisions and legal reasoning application, and some pretty high level analytic philosophy to teach the class. I was pretty rigorous with that class, I thought. And David, I think, probably got the highest score in the class. Small class, but David got took the LSATs, crushed the LSATs. He said your class was key in the logic games. They've taken the logic games out of the LSAT now. Well, anyway, he got into Harvard Law School, which think is a I think it's a good law school. I think. Um, in fact, he was so confident that he told Harvard, I need you to hold my spot for a few years. I'm going to go to seminary first and learn the Bible. And they wanted him badly enough that he he did that. He ended up clerking for the Supreme Court, Justice Alito. And I can't remember what year he was clerking for the Supreme Court. I think it was probably like 2018, maybe. I guess it would have been like, okay, let's say he graduated 2012, 14, 3 years in law school, 17. Yeah, it might have been 18, 2018. But my point is that they only have four law clerks, and you know, maybe David helped with the reasoning a little bit. I don't know. I don't know. I'm not saying I get any credit for this. I'm just saying this stuff is powerful. It's highly relevant to what we're studying. Study logic. Get a good teacher, get a good mentor. Okay. Doesn't have to be me, it could be somebody else. And a labeling standoff, Justice Alito continues, would not help the court because that would mean that the bare text of Title VII does not unambiguously show that its interpretation is right. The court would have no justification for its stubborn refusal to look any further. As it turns out, however, there is no standoff. It can easily be shown that the employer's real objection is not attraction to men, but homosexual orientation. In an effort to prove its point, the court carefully includes in its example just two employees, a homosexual man and a heterosexual woman. But suppose we add two more individuals, a woman who is attracted to women and a man who is attracted to women. A larger employer would likely have applicants and employees who fall into all four categories, and a small employer can potentially have all four as well. we now have the four exemplars listed below with the discharged employees crossed out. Man attracted to men, women attracted to men, woman attracted to women, man attracted to women. The discharged employees have one thing in common. It is not biological sex, attraction to men, or attraction to women. It's attraction to members of their own sex. In a word, sexual orientation. And that, we can infer, is the employer's real motive. In sum, the court's textual arguments fail on their own terms. The court tries to prove that it is impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. But as has been shown, it is entirely possible for an employer to do just that. Okay, that's it right there. Good job. Good job, Alito. Quote, homosexuality and transgender status are distinct concepts from sex, unquote, at 1746, 1747. And discrimination because of sexual orientation or transgender status does not inherently or necessarily constitute discrimination because of sex. The court's arguments are squarely contrary to the statutory text. Now, let me just add something here, and it's a cultural observation, okay? Younger people are especially vulnerable here, especially, but also older people who have a temperament that want to be kind of people pleasers. In statutory construction, we're not asking what most people on the street at any given point would think is appropriate. That's not what statutory construction is. Statutory construction is a technical process of interpreting statutes that are passed by legislatures according to their rules, usually majoritarian, representative. It's a Republican form of government. There's representatives that are in a legislature, and they have rules for how to pass these bills or ordinances, statutes. And usually there's a presentment requirement, at least at the state and federal level. The presentment requirement would be a presentment to an executive to sign. So there's a whole process there of creating law, creating a statute, and how to interpret the text of that is the issue. And it's not simply what you think most people would say is okay. That's not what we're doing in statutory construction. And I think a lot of college students get confused here where that's not okay. Like, well, but I know you think that it's not okay. And that's like the MTV answer. Sorry to date myself. I have a VCR, but that's not the question before the court. This statute was passed in 1964, and it can be amended by the Congress under the same rules that it was passed in the first place. And so if you think that, and you think that that should be in the law, well, then get active politically and try to make that come about. But that's not what happened here, and that's not what the dissenting opinion here is saying. That's what the court should have done, and they didn't. And so there's something wrong with the court's role here. The court has a wrong role. We don't want to subvert the correct role of the court just because you think MTV has a different answer. That's not what we're doing here. It's a separation of powers problem. Okay. Last paragraph before we hit B and go home for today. But even if the words of Title VII did not definitively refute the court's interpretation, that would not justify the court's refusal to consider alternative interpretations. Ooh, he's driving the nail in even harder here. Further, he's pounding it with that hammer. Yeah. That's right. The court's excuse for ignoring everything other than the bare statutory text is that the text is unambiguous and therefore no one can reasonably interpret the text in any other way than the court does. Unless the court has met that high standard, it has no justification for its blinkered approach. And to say that the court's interpretation is the only possible reading is indefensible. Nice job, Alito. We're in Bostock versus Clayton County, Georgia, 590 U.S. 644. In the Supreme Court, in the U.S. reports, in the Supreme Court Reporter, it has different pagination on Google Scholar. We're in Roman numeral 1, letter B now. We just got to letter B. We finished A. And letter B, Roman numeral 1, letter B, will be next time. We had a reading from Psalm 32 today and Streams in the Desert, January 17th. Today is 12 November, 2025 years after Jesus. It's a Wednesday. I've enjoyed being with you today on the Republican Professor podcast. I hope that you're taking this stuff seriously. We'll see you next time.